Good afternoon, everyone. Please join me in thanking once more Governor Patterson for those wonderful remarks. I think if that beginning is any indication of the rest of the afternoon, we are in store for an extraordinary experience. I would say, actually, that today is truly remarkable. And it's remarkable, you might say, well, why? It's a work day. It's a Tuesday. It's gray outside. It seems dreary. The final days of the legislative session are at work. But what is remarkable is something about the subject matter today has drawn the former governor of the state of New York and 8 other speakers of extraordinary accomplishment and distinction. Equally remarkable is if you look around the room, look how many people are here. And even more remarkable is the subject we're going to discuss today is about the wonkiest, most technical constitutional political science subject you can imagine. Well, a word or two about the rest of the program. Of course, we're here today to talk about Silver versus Pataki, and we're going to be discussing how that decision has played an extraordinary role in the continuing struggle between the legislature and the executive over dominance in the budget process. That decision, I think certainly, and I can say without fear of contradiction, solidified the governor's preeminence in the budget process. Today we have, and I think Governor Patterson alluded to it, not just a chief executive, but a chief legislator in the budget process. And we're here to talk about how that's working, how we got here, and how well suited that process is for the needs of the 21st century. The balance of the program today will consist of 4 separate parts or chapters. The first 3 parts or chapters will be separate panels, each calculated and designed to accomplish a certain purpose. The first panel will provide, if you will, it'll help set the table with Governor Patterson's remarks, providing a orientation, a constitutional history, and some background as to the case. The second panel will actually have the prime movers, the participants in the decision that was Silver versus Pataki. The third panel will move from the abstract to the concrete. We'll talk about Silver versus Pataki in the real world. And the fourth panel will bring back most of our presenters and sort of open up the floor for a robust debate. Depending on how the time goes today, I may ask a few questions of my own. We're going to ask each of the presenters to speak for about 7 to 10 minutes. If we're moving along quickly, before we get to the final panel, we may open up the floor for some Q&A. For those of you from the audience, for those of you who'd like to ask a question, I just want to remind you, this program is being webcast, so rather than ask a question from your seat, we'd ask you to come to the front and speak in the microphone. Just one quick word of thanks and deep gratitude to our sponsors, of course, the Rockefeller Institute, the Government Law Center, Cisco, the Albany Hilton, which took care of some of our participants today, as well as Westlaw. So without further ado, let's move to the first panel. This is really remarkable because we have to my right 2 people who I can say, and I don't think anyone will disagree, are simply the best at what they do. And what is that? These are the authoritative experts. There are no better on either the constitutional history of New York State or political science as it is applied and in theory in New York State. Peter Galie, to the far right, is the author of, unquestionably, the leading book on the constitutional history. He is the Charles Lincoln of our era. To his left, Gerald Benjamin, well, he needs no introduction. For years, indeed decades, he has been New York's preeminent political scientist and commentator on all things government and politics in New York State. I now turn it over first to Professor Galie. Would you favor us with some observations about how we got here today?
Thank you, Hank, and certainly thank the Albany Law School and the Rockefeller Center for sponsoring this panel and inviting me to this panel. It's an area of interest of mine that has been consuming me for the last 25 or 30 years, and the fact that an audience of this size is willing to come to a lecture and discussions to talk about the Constitution and the way we do things in terms of our fundamental document is heartening. And I hope this is a good start on our way to a serious and thoughtful vote about whether or not to hold a Constitutional Convention in 2017. I'm here to give you, in a very short period of time, I would say thumbnail, but as I'm sitting here looking at the time, I think maybe it's more like a fingernail, a look at how we got from no budget to the executive budget in New York. This is a relatively simple task, but an important one. And its history, however, is fraught with at least one pearl. And that pearl was pointed out by Anatole France, who once had one of his characters remark of a scholar the following: "He is truly a great historian. He has enriched his subject with a new uncertainty." Well, I hope that doesn't happen here today. I'm going to just sketch out 5 time periods with regard to the budget in New York State. Phase 1 I call the phase of legislative dominance between 1777 and 1900. Until 1927, the concept of a budget as a carefully balanced program of revenues and expenditures was foreign to the fiscal policies of the state. The early constitution of the state vested control over the finances of the state in the legislature. Period. Under those circumstances, the legislature continued to make appropriations regardless of revenues. They borrowed money for deficits as long as, at least in the 19th century, canal revenues were sufficient to pay the interest on those debts. There was scarcely any provision for paying down the principal of the debts. Partly, in fact, in response to those practices, the 1846 Constitution added the requirement that the state obtain voter approval for general obligation debt. It would be difficult to imagine a more disorganized and undisciplined process. Appropriations and items of doubtful character and unknown parentage were slipped into these bills and crowded into the legislature in a hurry, and in the confusion attendant to the closing hours of the session. The comptroller in 1863 referred to appropriation bills as an annual abomination. Today it's the big ugly. The only check on legislative extravagance was the power claimed by the comptroller to refuse to pay illegal appropriations. He refused to pay an improvements on the Bouquet River, a river described by the Court of Appeals as one whose name is not found in any general history of the state and is not found on any general map of the state. This refusal was the only legal check which existed at the time against legislative extravagance. And some reforms made things worse. Making executive offices elective creates a plural executive, making the comptroller accountable to the legislature. These appeared to be extensions of the separation of powers, which Jerry is going to talk about. But in fact, they were an extension of the principle beyond the division of responsibility between the branches of the government, coordinate branches, to divisions within the branches themselves. Phase 2, 1900 to 1927. And by the end of the 19th century, we began doing a lot of things in New York State. The government did. Healthcare, roads, educational activities, labor, conservation, agriculture. In the years between 1850 and 1920, the aggregate ordinary expenditures of the state went from $894,000 to $94 million. Now, why is that significant? Well, spending on such a large scale simply required some change in the haphazard quality of the fiscal policies of the state. At this time, no administrative officer acquainted with the entire business of the state reviewed estimates submitted by various administrative services. No balanced budget was ever submitted to the legislature. Now, governors before the coming of the executive budget under Smith did attempt to bring some order to the process. Governor Hughes deserves credit, Governor Sulzer, and Governor Whitman. And the 1915 Constitutional Convention actually proposed an executive budget. That Constitution was rejected. The legislature did pass the Sage-Meyer Bill in 1917. I single this out for your information because it attempted and did to some extent succeed in creating a legislative budget. First time. Well, it wasn't adequate. And the galvanizing event that precipitated the executive budget in New York State is the election of Al Smith to the governor. And it is fair to say that the governor's role in finance at that time could be described as follows. Not only was the governor of New York State not a chief executive, but in the formulation of financial programs of the state, he has practically nothing to say. That was the state of things when Al Smith took office. Well, he achieved a number of things you're probably familiar with: the consolidation of boards, offices, and commissions into a few great departments of the government, vesting the power of appointment and removal of department heads in the governor, a consolidated budget system with accounting controls over spending, the executive budget, which was adopted finally in 1927. So a revolution had occurred. We had moved from a budget system dominated by the legislature to a budget system now in the hands of the executive. Phase 3, consolidation, 1927 to 1940. Here, some very able governors who actually were interested in budget matters, Roosevelt and Lehman, coupled with important court decisions, put this new system on a strong footing. Phase 4. What I call discontinuous aggrandizement, 1940 to 2005. We had a constitutional amendment in 1938 which eliminated the phrase clearly itemized estimates. Now, why is that important? As you're going to see, that was a way of loosening up the ability of the governor to move funds around when clearly itemizing things became impossible or were simply impracticable. And that was one important point. The other important point is, what you're going to hear from the individuals here today, almost every decision that the Court of Appeals made, not everyone, but almost every decision, either reinforced the principles of the executive budget or amplified them. So the constitutional amendment, the decisions of the Court of Appeals, and executive practices and precedents by competent, capable, and ambitious governors combined to make the executive budget system what it is. The last point, there was a period, at least according to some legislatures, of what we might call the golden age in executive budgets, where there was more balance between the two. Just as a matter of historic interest, in 1997, SUNY Stony Brook sponsored a symposium called the New York State Budget Process, Past and Present. And I mean, they had just about every past budget director or council of governors at that conference, as well as some legislators, and it went very well. But what I was struck by reading the transcript is that they felt that the governor doesn't dominate the Albany agenda, that we have produced a legislature that takes control very seriously and a much more vigorous, healthy process than it was 30 years ago. It almost looks like a golden age from the point of view of these, the individuals at this conference. The big issue, they thought, was a timely budget. Now things have changed. Phase 5, and the last phase, executive dominance, 205 to 215. An article in the Albany Law Review in 205 concluded, the governor is the undisputed master of the financial affairs of the state. And that is the situation we face today. And the question we face today, the difficult one is there an imbalance in that situation? Have we gone too far in the direction of the executive budget? I'm sure that will be the dominant question we talk about the rest of the day. Thank you.
Good afternoon. Thanks to the Albany Law School and the Rockefeller Institute for inviting me. I see a lot of, I'm inclined to say old friends, but I'll say long-term friends in the audience. I'm going to talk to you today about separation of powers in New York, to contextualize the discussion of the decision and its consequences. The defining aspect of the budget article of the New York's Constitution is the reversal of conventional separation of powers roles in lawmaking, as you've heard. We learn early in life from Schoolhouse Rock, some of you remember I Am a Bill on Capitol Hill, which I reviewed for this presentation. It's that's one of the beauties of technology. That the legislature makes the law subject to executive veto with, of course, the possibility of legislative override. But for budgeting in New York, the executive writes and metaphorically passes the law and turns it over to the legislature for consideration. The legislature can exercise what amounts to a reducing item veto, but otherwise may not change the law. There are additional important distinctions in the interactions between the institutions. The most crucial one is that we retain a residual core of the revolutionary era principle of legislative control of taxing and spending. There's no formal override for the governor, as there is in ordinary lawmaking. That is, the legislature makes the law, the governor has the veto, and then the legislature has the override. There's no analog to the override, or at least there wasn't until Governor Patterson thought one up. This combined with a regularly recurring annual deadline and a requirement that the legislature give the governor's legislation in this area priority distinguishes budgeting from all other legislative matters. And it also, because of the absence of the override, elevates the prospect for deadlock and alters the politics fundamentally. Of course, there are very many other informal aspects, but these are the fundamental structural questions. Some think this is a violation of the separation of powers, but of course, at the national level, there was never a fully constitutionally defined separation of powers in New York. Not the governor, but members of the judiciary dominated the review and approval of legislation initially under the Council of Revision. Not the governor, but senators selected by the Assembly annually and the Council of Appointment dominated the appointment process. So, as Richard Neustadt, the great political scientist, noted, we don't have separation of powers. We have separate institutions sharing powers. And the question is the character and nature of the sharing and, as has been mentioned, the balancing. Budgeting is a different kind of sharing than for other legislation. The current arrangement, as you heard, was a reaction to deep dissatisfaction with how state government was working, with the legislature at the center of not budgeting, but taxing and spending. Now, so one lesson, and encouraging for some of us who favor the idea of calling a constitutional convention, one lesson is that if things get bad enough and the political coalition is diverse and strong enough, very important institutional change is possible. Either by formal action or by judicial action. As we need to remain, as we think about institutional change, we need to remain mindful. I'm having difficulty because I have these trifocal glasses, and every time I look at you, I lose my place. So I'm going to stop looking at you. Forgive me for my rudeness, but I'll be able to see my remarks, which, after all, is the function of this presentation, or are the focus. We need to remain mindful that state constitutions are significantly different in function from the national constitution. Very, very important. As G. Allen Tarr, a leading scholar of state constitutions, has said, the federal constitution restricts the federal government both by prohibitions on what the government can do and by granting the government only limited powers. While state constitutions, the second restriction is missing. The state exercises plenary power, the state legislature exercises plenary power, and the only limits are those inserted in the Constitution. So state governments, in their design, are not simply junior versions of the national government, and state constitutions are not simply a pale imitation of the national Constitution. Now, legislative power is plenary, except if constitutionally limited. A lesson I learned when Governor Patterson appointed a lieutenant governor, and I said, oh, no, that's not constitutional, and Richard Perfault differed, and Richard Perfault prevailed in that conversation and in the courts. That is, the legislature in that case had acted generally, and absent a specific action, the general action prevailed. So the power is, except if constitutionally limited, is plenary. But there are methods of constraining the legislature. 3 categories are in the Constitution that come to mind: process limits, the 3-day rule. Peter has a book coming out called The Potemkin Constitution, and he raises In 12 chapters, he raises all those provisions of the Constitution that don't actually do what they say they do, and the 3-day rule is one of them. He's written about that. Substantive limits, the forever wild provision, home rule requirements, limit the legislature substantively, and directives, things that tell the legislature what to do, for example, the education article. So there are ways that we have contrived to limit the legislature or direct it either by direction, process, or substantive constraints. Now, what New York constitutional history is all about is constraining the legislature by increments. John Buckley, who published an article in, Judge John Buckley published an article in 2005 in the Albany Law Review, which he does a very good job of summarizing the process, the steps by which the legislature was incrementally over several hundred years of history constrained. And we can raise some examples. The executive veto, the ban on lotteries in 1821, referendum for full faith and credit borrowing, which we heard mentioned, automatic referendum on a convention, the creation of a multitude statewide elected offices. And by the way, separation of powers in state government involves, and Peter and I appear to disagree on this, which I didn't know until moments ago, the creation of statewide elective offices is a way of constraining the legislature, because the legislature can no longer appoint those people once they're elected. So the separation of powers principle reaches a range of interactions and invests in the people authority to create resistance to or constraint upon the legislature by their selection and the empowerment of those offices. But the incremental diminishment of the legislature did not lead to the empowerment of the governor until the progressive era when an all-star cast, Charles Stimson, Elihu Root, Seth Low, Governor Hughes, and the greatest governor of our recent history, Alfred E. Smith, and I say that as a great acolyte of Nelson Rockefeller, but you know, he has to concede to Smith in my opinion, offered a streamlined bureaucracy with gubernatorial appointment, diminished numbers of statewide elected offices, a 4-year elective term for governor without term limitation, and executive budgeting. So, as Peter noted, the transformative moment for empowerment of the governor did not come until the 20th century. The legislature, interestingly, and this is a curiosity for his history buffs, between 1915 and the passage of the budget provision of the Constitution, attempts were made to pass it in the legislature on several occasions, and the legislature had a chance for a much better deal several times, including the potential opportunity to increase the governor's appropriations as a compromise was sought. But there was a return to the 1915 formulation ultimately when Smith and the Democrats got sufficient power to push the matter through. And the legislative library is a great resource for people who want to examine the detail of those proposed amendments. So legislature in the decades since the 1920s, as Peter has pointed out, has suffered not only from constitutional change to limit it, but from poor judgment in legislative leadership in the face of change. I think withdrawal of the second iteration of the constitutional amendment by Speaker Silver in a apparent negotiation with the Governor Spitzer was a bad mistake for the legislature as an institution. And the court interpretations that have been pro-executive largely, from unintended consequences, from changing social and political conditions, all this might come up in the discussion. In recent decades, long-time divided partisan control of the two houses made it harder for the legislature to defend its institutional interests. Transformations in the communication environment and simplifying social assumptions. The governor has become the reification of the government, has made it hard to take on the decline in legislative role relative to the governor in budgeting and in other matters. And there's been the corrosive effect of corruption. So the government, in more ways than we wish to acknowledge or accept if you're interested in the separation of powers and the democracy as the legislature as a locus of representative democracy, has become the government. The court spoke with a divided voice in Pataki against Silver. We'll hear more about that. The New York State legislature is not toothless. There's no rent control legislation at the moment, and that's a significant fact. Proposals for reform of the legislature have been received not received well by the legislature. The legislature has not acted in its best interest for political and institutional reasons, in my opinion. And so, and we continue to find it hard to imagine, at least I do, that if you put a legislature empowering element before the people of New York, that they would support it at referendum. So it seems to me that most fundamentally, Pataki against Silva shows that New Yorkers need a new conversation about how our legislature should be constituted and empowered, and more generally, what we expect from our representative institutions. In other words, we're talking about budgeting, but the need and the challenge transcends budgeting to the fundamental expectations in a representative democracy of the legislative institution and what its function and purpose should be. We have to state our expectations, our desires, and how we intend to get them. I think this is a start of that conversation. I'm most pleased to be a participant in it. Thank you.
I have two quick questions, one for Professor Galie and then one for Professor Benjamin. Peter, it's fashionable in some circles to talk in terms of original intent when construing a constitution. As a student and scholar of Al Smith's efforts and Stimson and others in 1926 and 7 to shepherd in the changes that have created the modern Article 7 of the Constitution, would the founders, if you will, the founding fathers of Article 7, would they have envisioned Silva versus Pataki?
First, let me add to the question that you would have to include the change in the 38th Convention, which also enhanced the governor's power. I don't think any decision made by the court up until 2005, or any actions by the governor, in any way could be seen as going beyond or counter to the character, purpose, and spirit of the initial 27 Amendment. Problem I have with the Pataki decision, if I read it right, I'm hoping to learn a lot about the constitutional law of that case, is it allows governor, by use of policy language, to countermand statutes already in place. If it does that, and I'm willing to learn, then I think you really would have something that could be argued goes beyond the spirit or character of what an executive budget was about.
Professor Benjamin, could you, if you know, give us some sense of how New York's executive budget process compares with our sister states, say of comparable size?
I can't answer in detail. I've read some general works on that subject. And it appears to me from those general works that there's a description and presumption of legislative role and power that exceeds the role and power of our legislature as currently interpreted. There are actual charts and tables in the Book of the States that purport to specify each step. There's also a measure by Thad Bile, a political scientist from North Carolina, that attempts to assess the budget power or score the budget power as part of the assessment of the formal role of governors, state by state. But when I looked inside that scoring, I've had sufficient concern about the scoring for New York to be skeptical. There's also a journal article, you're going to be sorry you asked this.
Not at all.
There's a journal article recently written that attempts to rescore the budget powers, to include the implementation part of budgeting as well as the adoption of budgets. I'm in touch with that professor who happily now works in New York State at Stony Brook about her analysis, so I could answer the question better after we've had our interactions.
Well, great. We're going to have a chance to have more questions asked of our colleagues later. In the interest of sort of moving things along, let me first again, and everyone join me in thanking these two distinguished professors.